Okay, I think we can go ahead and get started. Hello, everyone. My name is Paige Murata, and on behalf of US Law Network, we welcome you to this US Law Remote Learn webinar. US Law Remote is a series of virtual offerings ranging from our brand new podcast to roundtables and more. I am going to send a link with more information through the chat, so if you'd like to learn more about these offerings, go ahead and check that out. Today's webinar topic is navigating tariffs and supply chain challenges. Since this session is set up as a webinar, your microphone and camera are turned off, but you can use the Q&A feature to post any questions and comments, and our panelists will do their best to answer them as they come in. Now I will turn it over to two of our member attorneys and allow them to introduce themselves.
Thank you, Paige. Good morning or afternoon, everyone, depending on where you're located. I'm Caryn Boisen, and I'm a partner at the law firm of Larson King. Our main office is in St. Paul, Minnesota, which is where I'm located. We are the we are the U.S. law firm for the state of Minnesota as well as the state of North Dakota. I practice primarily in construction law. Most of my clients are general contractors or subcontractors in the commercial construction arena. I do sometimes also represent owners or project developers as well. I will turn it over to Jack to introduce himself.
Hello, everyone. My name is Jack Sanker. I'm a partner here at Amundsen Davis. We are the U.S. law firm for construction in Illinois. Similarly, a lot of my clients are subcontractors, general contractors, things of that sort. I'm mostly on the litigation side of things. And happy to talk about this topic, which as we're putting this presentation together, we realized it's very much in flux. So by the end of this presentation, everything may have already changed.
Very true.
Enjoy it being relevant for as long as it is.
Very true. And we're not here to make any kind of political statements or commentary about whether tariffs are a good thing or a bad thing. We're just here to kind of offer the lay of the land. And given the fact that Jack and I are both construction-based attorneys primarily, this presentation will have a little bit of a construction focus, but most of what we're saying also can apply in other industries and in other contexts as well.
Yeah, anyone in the supply chain, retailers, importers, et cetera, I think you're going to have something to take away from this.
Absolutely. All right, so let's just take it kind of down to the base level here about what are tariffs. A tariff is essentially the same thing as a tax or a duty. If you've ever flown internationally, you always walk through or very near a duty-free shop. That means that there's no taxes, sales taxes on those items sold in that shop. So a tariff is a type of tax. It's collected at the port of entry by one country, and it's assessed against the importers of goods from other countries. So in other words, let's say that we have a tariff now, 10% tariff on all imported goods from China. And company XYZ is a Chinese company. They want to import the widgets that they've manufactured into the US and sell them in the US market. So then when those goods are imported into the US, when they enter the US, the United States imposes that 10% tariff on the value of those widgets. And so then for that company, that Chinese company, to sell their products in the United States, they have to pay to the US government a 10% tariff on the value of the widgets. That's essentially how they work.
So who's paying the actual tariff? It's the importers, the folks that are seeking to put their goods or widgets into the United States market. Those are the importers, and they pay the tariffs to who? The US government. And essentially it's a tax for the right to bring those items into the U.S. domestic consumer market. The kind of the substance of this presentation, the reason that it's I think that folks that have been in this industry, or if you work in this industry, you're going to be answering a lot of questions, or at least thinking about this a lot, is why do we care about tariffs? The construction industry in particular. Well, the concern is that an importer, when they are faced with a new 10% or 25% or 40% tariff on whatever it is they're importing, are going to then adjust their pricing to accommodate for that, and then ultimately seek to pass those prices and those additional costs on to the buyers, which are the folks in the U.S. domestic market. So you can avoid, if you're, US buyer, if you're a domestic consumer, you can avoid these tariffs by buying US made. And, that seems to be the political impetus behind this overall like tariff project, if you will, to stimulate domestic production, et cetera. But for those that are relying on things that are coming through the international supply chain, there's likelihood to see price fluctuation based on the new tariffs.
And this is particularly a concern, I think, for certain industries like construction, where you have a lot of long lead time items. So things that you have to purchase and order months in advance of when they actually are going to be utilized on a construction project. And so, things that are going to be used, in 6 months on a project may have to be ordered now. And so the idea is that you can't all of a sudden just switch gears and then turn around and buy them from an American manufacturer because you've already ordered the stuff. So as Jack alluded to, one of the possible outcomes of tariffs is that prices for US buyers go up, because that company that's importing the goods, if they have to pay that tariff to the US government, then they're just going to tack it on to the price tag of whatever they're selling into the US. Another possible outcome is that foreign importers would sell less goods into the American market. If they don't want to deal with that, if they don't have a good market for their product, if they increase the price, then maybe they just will sell into other markets. There could possibly be shortages of materials or delays in procuring materials. There also, there have already been a lot of supply chain issues ever since really kind of the COVID, height of the COVID pandemic. And so this could lead to even additional shortages or delays in the supply chain. Prices could go up just due to the scarcity of the supply. If there's more of a demand for these items, the prices will likely go up. And then also, as Jack said, probably one of the kind of impetus of putting these tariffs into place is that the scarcity then of the foreign widgets that would otherwise be imported into the US could induce demand for domestic suppliers, which would lead to increased domestic production. The idea would be that US companies would then start manufacturing more things on American soil.
Yeah, so there's areas that are much more specific to our industry, being construction, that we're going to be focusing on today. Specifically, the tariffs that have been announced. Now, they've been adjusted several times already. They may be adjusted further, but as it stands, a 25% tariff on goods from Mexico and Canada, and then a 10% tariffs on goods from China. I actually believe the Chinese number may have been adjusted recently, but the principles that we're talking about here are going to apply just the same. So why are these things important? Specifically with respect to the Mexican and Canadian tariffs, it's because the nature of the things that we import from those countries are, particularly relevant to the construction industry.
Let's kind of break that down a little bit. So specifically to the construction industry, there was in 2023, there was $8.5 billion of wood products that were imported into the US. And of that $8.5 billion, $5.8 billion came from Canada. So approximately 70% of the total wood product imports into the United States in 2023 come from Canada, which is now potentially subject to the 25% tariff. In addition to that, there's other products and goods that are imported into the US from Canada. And for example, Ontario, Canada actually supplies electricity to the state of Minnesota, the state of Michigan, and the state of New York. And so if there are tariffs imposed on that electricity, that could have an impact certainly on any users of electricity, which would certainly be applicable to construction projects and other industries as well. With regard to Mexico in particular, we have a statistic here that $456 million of lime and gypsum was imported into the US in 2023. These products are used in drywalling and insulation, among other things, but those are primarily what their uses are for. And of the imports that came into the US in 2023, $352 million of that came from Mexico, which is again about 20 or 70% of the total imports. Mexico also has a really thriving electronics manufacturing business, and many of those electronic items will get eventually imported into the US. We didn't have a thing on here about China, but an important thing to note about China, which also now has the tariff in place, is that they're a very major global manufacturer of a lot of different construction related products, including steel and glass, roofing products, cement. A lot of cement is manufactured in China. So all of these things just show that there is potentially a big impact on the construction industry.
Yeah, and to some extent we are trying to predict the future here, but there's a lot of data to draw on as to why we think and why a lot of people think that this is going to impact pricing. It's not so much that we're claiming the sky is falling or anything along those lines. It's we can look at recent history and find some pretty good examples of how this actually shakes out, specifically with respect to the items that are being tariffed and the countries that the countries that the tariffs are being applied to. We don't have to look back much further than the first Trump administration from only a couple of years ago. So the increase on aluminum and steel tariffs, for example, is an increase upon already increased tariffs that were put in place during the first Trump administration. And I believe that the additional increase in 2018 was it was 10%, and now we're at 25%. So with that in mind, this is broadly what a 10% increase tariffs on steel and aluminum did. We did see a pretty steep increase in the price of the materials. The data on this is coming from a lot of different places. Some of it's self-reported polling, which, take it or leave it, I suppose. But the Bureau of Labor Statistics does a really great job at tracking this stuff. I spent a lot of time kind of poking around there, looking at commodities and imported good prices over the years, which showed a pretty clear trend here that after the tariffs are announced, you see a decent price spike in those items. You also saw a lot of individual companies that were reporting overruns, both in budgets and then, of course, on their timetables. And it was the start of the pretty dramatic spikes that I think we're all familiar with, the cost of new construction going way up. And it's continued to go up, obviously, every year. But it really, really started in 2018, of course, through the roof during COVID, but has continued since. And, these tariffs this time around, they were announced in February of 2025. I did want to look and see how the supply side of the market was reacting just to the announcements, and I managed to pull up some data from the Bureau of Labor Statistics. They published a lot of data on this. One is the Producer Price Index, the PPI, and the average price increase over the 12 months prior to the announcement. So like February to 2024 through February of 2025. On a lot of certain goods, but I looked at inputs to construction industries, et cetera. You saw a price increase of anywhere from 0.5% or so, which seems to be pretty standard, especially in an inflationary environment. However, from February to March, so this would have taken into account the announcement of the tariffs. The price increase there is like 0.5% to 1%. So just in 1 month, you're seeing an increase of prices like in certain construction inputs that took previously 12 months to get to that number. So it's been a pretty dramatic response.
So what do we do? What do we do about this? We want to come up with some strategies that could be used to potentially account for price increases resulting from tariffs, assuming that is the result. And one of the reasons why this is so relevant, I think, to the construction industry in particular is because of the margins in construction. It's a really pretty low margin industry. And so any kind of price fluctuation can have really a dramatic effect on how projects get done and whether they get done. And obviously this impacts a lot of aspects of American life, right? I mean, we're talking not just private construction projects, but there's a lot of public construction going on, a lot of infrastructure. You think about all those things as well that could potentially be impacted. So what do we do about it? What is this? How can we account for price increases resulting from tariffs if indeed that is what happens? So step one we would recommend is to review and evaluate the existing contracts that are already in place to determine how they may accommodate tariff-related market shifts. So, again, with construction, you have a lot of contracts that are entered into well in advance of a project even being started, much less finished. You look at some of the larger construction projects that can take years to complete. And so a lot of these contracts have been entered into months, if not years before today. And so there's some different clauses that are often used in construction contracts and in other contracts as well that you can look to and read them to see if they could offer any relief in terms of something that would happen, unforeseen circumstances like a tariff that may arise while the contract is in place. One of those is force majeure, which we'll talk about a little bit more about in a few minutes. Another is there could possibly be some kind of price escalation provision in the contract. It's possible that this may have already been sort of foreseen ahead of time, and that those who drafted the contract included some kind of provision to deal with material price escalation that happens during the pendency of the contract. There also are change in law provisions, which we'll look at a little bit closer in a minute. And then there's the potential for change orders. One issue about change orders is, typically change orders are entered into when there's been a delay or a reason why the contract time needs to be extended. Also, if there's been a change in the scope of the work that would require some kind of price fluctuation, either up or down. A change order could be a deductive change order and actually take scope away and therefore lower the price. But the one thing about a change order is everybody has to agree to the terms. So if you have a contractor that's coming to an owner and says, hey, I need a change order because now my material prices have gone up significantly, and therefore I need to get more money out of you, owner. In order to have a change order, the owner has to agree to that. And so that's not always a possible avenue, but it's something that can be looked at as potentially a way to account for price increases that happen after the contract has been entered into.
And this is going to be heavily jurisdictionally dependent, but there are common law and equitable options as well, things that are not necessarily written into the contract, but have been written into the law as to how the contracts can be interpreted. And those are frustration of purpose and possibility, commercial impracticability, and government action. Each one of those requires its kind of own separate analysis, and I'm not going to do that here, frankly. But there are additional off-ramps besides those things that are expressly contained in your contract, and things that common law avenues for relief that, if you find yourself in a bad situation, you ought to be able to evaluate through your counsel, whether it's in-house or external counsel.
And a lot of these common law doctrines obviously are not construction specific too, so that might be another avenue for those of you who are looking at this outside of the construction industry. Because with construction, a lot of the contract terms are pretty standardized across the industry. So, but I know in other contexts, they're certainly not. So let's look at force majeure specifically as a type of clause to potentially look to. So most construction contracts contain what's called a force majeure clause. These are events that are really outside the control of any of the parties. And so they use the term acts of God, but it's meant to be things like natural disasters, civil unrest, perhaps a terrorist attack, things that the parties could not control and that therefore cause some disruption to the project. Typically, force majeure clauses are limited such that they really only provide relief in terms of the schedule to complete the project, not increased costs. And so when you look at like COVID, for example, a lot of contractors try to invoke force majeure clauses during COVID because with lockdowns and with requirement to be socially distant, which is difficult on a project site potentially, a lot of testing was being done and other things. that just really increased the time needed to complete projects. And so a lot of contractors looked to a force majeure clause saying, hey, owner, all of this stuff, because people are out sick, because we have to take the time to test people, because we have all these socially distant requirements in place, et cetera, this project is now taking us X days, weeks, months longer than it would have otherwise. Interestingly, with regard to tariffs, most courts, at least as of now, have decided that a tariff, at least the courts that have looked at this, that a tariff is not a force majeure event unless the force majeure clause specifically references tariffs. So most force majeure clauses are going to list certain things. They'll have some kind of like a general provision. If something happens that is outside the control of the contractor, for example, acts of God, floods, natural disaster, unusual weather events, etc., then the contractor can request relief in terms of additional time to complete the project. But unless it specifically says tariff in there, chances are, depends on the jurisdiction, but chances are the court will not take that force majeure, take that tariff as a force majeure event unless it's specifically set forth in the clause. Interestingly, some contractors had trouble getting any kind of relief under a force majeure clause during COVID because a lot of force majeure clauses that were written prior to COVID did not specify pandemic as a force majeure event. Now, and I don't know about you, Jack, but now every single force majeure clause I see specifically references pandemic as one of these unforeseen circumstances that triggers the ability for a contractor to ask for additional time. Oh, do you want to talk about this before I go on?
No. I was just going to say the force majeure thing. From what I understand during the pandemic in particular, it was just also the owners had to. I mean, if they wanted the work to continue, they more or less had to. So there wasn't really a choice. It's a little different this time around because it's not. I mean, this is just a pricing issue for the most part. Now, unless there's a true blue scarcity event, which is kind of separate. Like if an item or a material that's required by the contract is just not available for purchase because it's become in such short supply, one thing or the other, then you're looking at probably maybe still not force majeure, but like the things I mentioned earlier, like impossibility and commercial impracticability, things like that, those will come into play. But going back to like what the contract can do to help you here is the change in law provisions. These are kind of interesting because technically the law has not changed. The law with respect to the ability of the executive to set these tariffs one way or the other, to adjust them up or down. Most of the individual tariff increases were granted by Congress because the tariff power is a congressional power that's been delegated to the executive via statute, which were passed in most cases, I think as recently as the 1970s. Different points in kind of U.S. history where there was like global trade renegotiation or whatever, Congress has passed these bills that allows the president to kind of unilaterally tweak the tariffs based on one thing or another. And there's a bunch of different statutes going back over the past 100 years where Congress has given this power to the executive. So the actual law on the books with respect to, can the president move the tariff number up or down is, in many cases 60 years old, right? So it technically hasn't been changed. However, a lot of change in law provisions that I've seen at least are echoing what happened in 2018 already, where many of them actually do specify that tariff changes are a material change to law. And then you have your change in law provision that comes into effect. And importantly, the way that the federal acquisition regulation deals with tariff increases, it just automatically considers those things to be changes in law. And it seems like courts tend to get their cues from that because the government does so many contracts. It really kind of depends. I think you're much safer including specific language that says change in tariff is change in law. If it doesn't say that, I can't tell you one way or the other for sure how the court is going to treat your individual contract if you're trying to, enforce your change in law provision based on the tariffs. I don't know for sure one way or the other. It also depends on where you are in the supply chain. Because if you're directly buying from an importer, then the tariff is, it's tariffed item, importer price goes up, you're paying that. It's arguably you are paying the tariff yourself, right? But if you're several layers down and you're buying from folks that have brought these things in, resold it, it's made its way through different supply chains or whatever, are you really paying a price that is, kind of directly related to the tariff? Or are you just paying an increased price due to, all these economic inputs, many of which are going to be tariffs, of course, but like every time, an item goes down, there's the markup of cost plus the profit margin, the markup of, those things. So you may have a harder time arguing in that situation where if you're buying something that has been through several layers of the supply chain, that it's really because of a change in law. And it's not just because of a change in price by the person who was selling it to you, just like market change, just like anything else. So it's tough. If you're, we'll talk about this later, but if you're sitting down and writing your contract today from scratch, in a perfect world, you would definitely specify that tariffs are going to count as a change of law when you're negotiating with the other side.
Okay, so we've talked about what to do with existing contracts and some potential strategies to deal with price increases resulting from tariffs with existing contracts. What about for new contracts? What do we do there? So obviously this is a little bit easier situation because you're not dealing with already existing language. I mean, in the construction industry, as I mentioned, there's a lot of standard contract forms that people use, but they can be modified. And Jack and I talked about this in preparing for today, that we've both had so many conversations with clients and others over the last month about this very thing. What language can we negotiate for? How do we word this? And so, the parties to contracts are starting to get pretty creative. And one option is to allow for cost sharing if there is some kind of price escalation with the materials. You could, part of it is, is it a material increase? What is the percentage of the increase? So the parties just can contract to share in that based on, for example, the Bureau of Labor Statistics Producer Price Index, the PPI that Jack mentioned a few minutes ago. You could have that kind of as your base to go on. And then if the price increases above a certain level, then, maybe they split the cost 50-50 or some other way to agree to split the risk, essentially, that there's going to be a price increase. Obviously, the owner is interested in getting their construction project built for as cheap as they can. And the owner and the general contractor, is looking to make sure that they're getting paid for everything that they're spending. And as I mentioned, construction tends to be a pretty low margin business. And so to have a tariff that could potentially increase material costs by 25%, that's someone's going to take a hit. And so the idea is, how can we negotiate this? And a lot of it is going to depend on the relationship between the general contractor and the owner. I was actually just on a call yesterday on behalf of one of my contractor clients with an owner, project owner for a new project. And we talked about this tariff situation for quite a while because, trying to figure out how both parties can be best served so that the owner makes sure they get their project built, but that the contractor doesn't take a complete hit. And the other issue on this is that, it's pretty unusual, particularly in the commercial construction space, that you only have just the owner and the general contractor to worry about. You also have all of the subcontractors that come under the general contractor who are taking on different scopes of the work. And how can those companies bear the risk as well, which is tough. Because you get into a situation where, as you're getting further down the subcontracting chain, a lot of times those companies are pretty small and kind of mom and pop shops or certainly family businesses. And companies of that size particularly can't bear the risk of having such increased material escalation because they just can't bear it. So a lot of things to think about.
The next couple of slides may be a little boring, but let me tell you, this is actually like the meat and potatoes of this presentation, because this is the stuff you really actually, it's where the rubber kind of meets the road here. Because each of us is probably using at this moment an AIA form, or, you know, are working based on an AIA form or things like that. AIA forms are, you know, they've been putting out these contract languages that you can use for like 120 years now. Many of the actual terms and subparts have been litigated and interpreted by courts, so you could usually rely. It's kind of the gold standard for boilerplate contract language. And so the issue is, you know, if you're really looking at your contract and saying, okay, I want to take a look at this and protect myself or whatever, you're probably going to have to get a bespoke draft of the contract, or kind of custom made for what it is that you're worried about, because the AIA documents as are available, you know, when I put this presentation together a week ago, do not directly address tariffs in a way that we would want them to if we were going to start from scratch today. For example, there are delay provisions and change order provisions that discuss taxes and rate and increase on taxes of certain goods. And you can account for that depending on which side of the contract you're on, but you can account for that however you need to if you're using AIA form A201, for example. But what it mentions there is, you know, taxes, it defines them as like sales, consumer use, and similar taxes. Tariffs aren't exactly a sales tax. They're not exactly a consumer tax either. I mean, they're an import tax. It's kind of its own thing. So are those quote unquote similar taxes? And courts have not decided that. We don't know. I don't think so. It's hard to say, but the it's, you know, more likely than not, your contract, which is going to be based on AIA language, I'm almost certain, doesn't account for these things adequately. Similar to some of the delay language that you're going to see, you know, the force majeure language, which we talked about before, labor disputes, fire, unusual delay in deliveries. That's kind of an interesting one. Quote unquote unusual delay. I mean, I don't know. We've had shortages before. We've had supply chain issues before. Courts have looked at that stuff and decided whether or not the force majeure clauses or your delay or change order clauses are going to come in, you know, are going to be interpreted favorably. It's going to vary based on jurisdiction. But by and large, you can't just rely on what you have. And I think it's like, if I'm going to boil this down to, you know, a simple way of putting it, your contract likely doesn't even contemplate this type of trade dispute, because we really haven't had something like this in, you know, in recent memory.
Yeah, one piece about that taxes language too that is quoted here on this slide, you know, even if you do get over the hurdle, arguing that tariffs are similar taxes, the other piece of it is, you know, taxes, this clause comes from where it's defining what the cost of the work is. And so the other rub is a lot of times these contracts have a guaranteed maximum price where the contractor agrees that they will not exceed that guaranteed maximum price. And so you could have a situation where even if you get over the hurdle and successfully argue that tariffs are similar taxes, whatever the increase of material costs bumps up the contract above what the guaranteed maximum price is. And so then you're kind of stuck there too. So it's not an easy argument for sure. One type of clause that we're starting to see now being put into contracts is to have a tariff specific price escalation provision. And that, you know, I'm not going to read through this whole thing, but essentially it says, you know, if there's if the goods that are being sold or materials that are being used exceed a certain percentage increase, then there's an opportunity to actually terminate the contract. There's termination clauses typically in construction contracts, but this one is particularly keyed into a tariff situation. And it contemplates not any tariff, but that if, because there is a tariff that has increased the cost of the materials being used on the project above a certain percent, then the ability to terminate gets triggered.
Yeah, so when I mentioned before that this stuff was kind of boring, but like kind of important, here's the type of language that you're going to want to be able to use. This is a little bit of a freebie now that I think about it. But this is and this is not from one of my contracts, by the way.
We're not here to give legal advice, though. Right?
I'm not giving legal advice, and this was something I found from public reporting, so it's not one of my clients. But this is an example of change in law language that can be added to a contract as you're renegotiating, or if you're signing a new one, that is going to specifically account for tariffs. You could see it specifically talks about the increase or decrease in or imposition of tariffs, duties, tariff rate quotas, fines, penalties, et cetera, et cetera. So this is the type of thing that you're going to want to see. And we will start to see, by the way, that everyone that's paying attention, at least that's signing contracts, as of now, at least the ones that are smart, are going to make sure that this type of language is included.
So I mentioned change orders earlier, and the fact that you can try to rely on a standard change order provision in order to argue that an increase in contract price should be put into place. But again, a change order has to be agreed to by all the parties. And so if you are a general contractor and you are arguing to an owner that you are entitled to a change order as a result of price escalation of the materials, the owner has to agree that there is a reason to change the terms of the contract and increase the contract pricing. So one way to get around that is to put a more contractor-friendly change order provision within the contract. And so this expanded change order provision that is on the screen now talks about that if new tariffs or other similar government-imposed charges are introduced after the time that the contract is entered into, then the parties will renegotiate the pricing in good faith. So this is, again, a very contractor-friendly provision, but it ensures that an owner is going to have to negotiate in good faith to reflect the price increase as a result of the tariff.
And the escalation clauses, change orders, things like that, I mean, they're typically addressing cost overruns and cost increases. Force majeure obviously is dealing with time and delay. And this is an example of, when the type of language that you might see included in the expanded force majeure language that, we think is going to be worked into more contracts. Adverse governmental actions, including but not limited to new tariffs, duties, or similar government imposed changes. So in a situation like that, you may, from the contractor side, be able to invoke your force majeure for additional time to perform, which may be needed for whether you're going to restructure financing or just to procure material that maybe is harder to get, or there's just not a lot of it. Who knows? But this is a modification or something like this that we think contractors will be, at least the ones that are paying attention and have good lawyers, are going to want to bargain for.
And one of the other things I just saw recently in a contract that the force majeure clause was modified to also say that in addition to additional time, that a contractor could ask for additional costs as well, resulting from a force majeure event. So you could modify it in that way as well. Okay, so we've talked about what to do with existing contracts. We've talked about some possible terms to negotiate into a new contract. And then we have kind of step 3 in our list of strategies to account for these potential price increases. So one way is to consider some alternative arrangements to allow for flexible price controls. On the contractor side, what does that look like? So the contractor, there could be an agreement between the contractor and the owner that the contractor will purchase imported items as soon as possible after receiving the notice to proceed. This would make it more likely that they're buying it at a time before potential future tariffs get imposed. You could, change the terms of this. So you say that the contractor is going to buy these imported items within a reasonable time after the contract has been entered into. That's another way to handle this. Another way, which is not bullet pointed here, is, some contractors are deciding that for materials that they use with frequency on projects, that perhaps they frankly just stockpile some of that stuff. I mean, it's a little bit difficult because then you get to, where you're going to store all this stuff and how you're going to insure it before it gets used. And there's a lot of other issues that come into play here. But if you are in a position as a contractor where you can order things in bulk and have a location to store it because you're going to be using it on a project sometime in the near future, that is a possible strategy as well. Another strategy that's noted here in the third bullet point is maybe breaking up the project into phases, such that at certain phases over the course of a longer project, there are times when there's sort of repricing points or almost renegotiation points. So that perhaps with a multi-year project, for example, halfway through or 2/3 of the way through, there's kind of a pause and everyone takes a look at what the pricing is and what is in place at that time. Because as Jack astutely noted at the beginning of this presentation, everything that we're talking about right now, could be moot next week. We don't know. We just don't know what's going to happen. And so having these kind of the project broken up into chunks so that everyone can take a pause and take a look at the current situation might be a strategy to deal with this. Another example would be that if the owner doesn't issue the notice to proceed, in other words, giving the contractor the notice that they're supposed to proceed with starting the construction, if the owner doesn't issue that notice to proceed within a certain amount of time, maybe you have a clause that the contract allows for a right to update the pricing. And then if the increase is over a certain amount and the owner doesn't want to pay, then the contractor can terminate, or maybe the owner can terminate. So there's ways around this. It's just the biggest issue is that, again, there's a lot of unknowns and there has to be a certain amount of trust, frankly, between the owner and the general contractor and the general contractor and its subcontractors as well, in order to make sure that none of the parties is bearing all the risk of this.
The owners have some other options here as well. It's more from the perspective of trying to avoid disputes or overruns or things like that. I was looking at what different trade organizations had to say about this and are addressing the kind of overall concerns regarding tariffs. The Associated General Contractors of America they do a great job of publishing on these things pretty regularly. If you check out their website, a lot of useful information there. They're recommending using cost plus agreements or like a guaranteed maximum price, which is going to, it's the cost, the inputs, the cost, contractor fees, and then a contingency that's going to be set aside for, when you need it, right? And the contingency obviously should have a cap from the owner side of things. That's something you're going to want to have, but it can be earmarked to include price overruns from tariffs or material price increases in general. That's something that you can include in the way that you structure the contingency, so that that bucket of money is budgeted for and is there if you need it. Kind of taking a step back from the contract of how you want to structure the job, owners can spread around the risk among the risk of price increases, shortages, things like that, by splitting up the job into different components or different phases. Smaller jobs, basically signing more contracts with different contractors, and it reduces the overall risk per contractor. And this is a whole nother can of worms, but for general contractors and or owners that qualify and that have it, subcontractors default insurance SDI could be a way to bridge a gap in a situation like this. And you don't actually, there was a really interesting decision on this recently. Depends on the policy, depends on the jurisdiction, all of those caveats, but you don't actually need to terminate the sub to invoke or to make a claim under your SDI policy. So if you're an owner or a GC and one of your subs breaches due to something like this, you can make a claim with your SDI insurance that will, ideally provide you the funds you need to keep the project moving, and you don't necessarily have to move off the sub. You might down the road, but it's not, it's not a precondition for the applicability of SDI coverage, again, subject to jurisdictional caveats and all of that stuff.
And SDI is really becoming much more commonly used. And so the way it works is that a general contractor will purchase an SDI policy and then it enrolls its subcontractors under the policy. And then, they would cover things like if you did have to hire a replacement subcontractor, if there's costs to address project delays, indirect costs such as liquidated damages, most SDI policies will cover those things. All right, so key takeaways for existing contracts. Again, review those project contracts or other contracts if you're not in the construction context. Consult with counsel on how the existing contract provisions can help with addressing the potential price increases or other market issues. Third strategy, to determine whether an existing force majeure provision can offer some protection. Usually, again, those force majeure provisions are going to be limited probably to time extension as opposed to a cost increase or price increase in the contract, but it's worth it to review it just to see. There might be other contract provisions, change of law provisions or other things that could provide some relief. And then, with existing contracts, it's important for the parties to have an open dialogue about this. Everyone wants to get the project done. Everyone wants to fulfill the contract and get the project done, and how to make that happen. Because the owner doesn't want to be faced with a situation where a contractor just becomes financially unable to perform. So hopefully the parties can sit down, and even if there isn't a specific clause that addresses tariffs in an existing contract, that they can talk about this and figure out how to handle the situation.
Yeah, and for those of you that are negotiating, a deal currently or going to sign one over the next couple of months, I mean, obviously you're going to want to pay attention as to, these tariff levels and where they settle, et cetera, things like that. But, whether you're on the contractor side or the owner developer side of things, there's some things that you could ask for, obviously, and then you obviously be prepared to respond to those asks if you're on the other side. The tariff specific, related language to be included in the contract. Some of the things that Caryn just mentioned a moment ago, the expanded force majeure and price escalation provisions, things like that. Expect those to be asked for if you're on the owner side, and if you're on the contractor side, it's a good idea to ask for them. The expanded change order provisions that are going to include tariffs again, and then from the owner developer side, you need to make sure that if you're including these things that you have capped your overall liability and capped your exposure to whatever these price overruns are. You can't kind of, just include open-ended language which says, you're going to share, for example, all the additional costs over a certain point 50-50, because what if that cost balloons to 300% or something, then you're now sharing that with the subcontractor in a way that just makes it impossible to do the work or to make the project happen. So you're always going to want to include your own limitations and caps on those things, along with notice requirements, etc.
And with that, we are happy to entertain questions.
I have a couple that were posed already, and some of which I tried to answer during the presentation. I'll read those first. I was asked if there's CLE credit available for the session. My answer was, I have no idea. Paige from USLAW chimed in and said, no, it's not available. I was also asked if the slides are going to be available by a couple of folks. My answer was, you have to check with USLAW on that. But if you, and I think Caryn will probably agree, if you want a copy of the slides, you can email us each individually. Our information's on the screen. I'd be happy to share that with you. One question which momentarily stumped me for a minute, but from an anonymous attendee, if the buyer is a governmental agencies, so DoD, U.S. Army, or federal agency, are the tariffs going to be applicable to that buyer? Are there any exceptions for the government as a buyer? And I kind of, it stumped me for a moment, and then I remembered that the government agencies don't pay taxes. So, yeah, right, yeah. So my answer to that question is no, but I certainly wasn't ready. Caught me off guard. But by the way, if you are a government agency that is buying from someone who has bought it from an importer, that price increase due to the tariffs may be priced into what you pay. So your prices may still go up as a buyer. You're not paying the tariffs directly, but you might be paying the downstream effect of the tariffs, for example. Let's see. Here's another question just came in. Have either of you had luck getting any of the contractor-friendly risk-shifting splitting contract clauses agreed to by owners, ergo splitting costs that increases over a baseline?
Yes, and I have. And one of them actually, we're still trying to kind of work out the parameter of how that cost sharing is gonna look. And so it's kind of a work in progress, but I'd mentioned earlier that I had a conversation yesterday with representatives of my client, the contractor, and then representatives of the owner. And we did talk a lot about tariffs and about implementing some kind of cost sharing provision. And so we haven't finalized what it's going to look like, but there's going to be some sort of cost sharing provision within the contract.
Yeah, I mean, I think it depends on how motivated and frankly sophisticated the owner is in that situation, because they should understand here the goal is to build the thing, is to perform the work, is to get the project done. And I'm sure that you don't like to see added asks from a sub for cost sharing and things like that. But if you're serious about getting the project done, then you should understand that these price increases may happen, and you want to make sure that your sub can actually do the work in the event of a huge spike in input costs. So if everyone understands how that's going to work, the owner and the contractor should have a pretty open discussion about that situation. And I think it would reflect well on the contractor, frankly, to be talking about those externalities and those contingencies. Although, as we all know, the owners are looking for oftentimes the smallest bottom line that they can get. So yeah, it could hurt you in the bidding process or however, you approach that. It's hard to say. I think if you're dealing with a smart owner, they should, appreciate this, and it shouldn't hinder you, but maybe on smaller projects or things like that where they don't really care, who knows?
I also recently had an owner suggest that if there is a material price increase as a result of tariffs, that it get considered as part of the contingency, which is another potential way of handling it. Although usually the contingency isn't going to be big enough to necessarily handle that, but it's a possible avenue.
Yeah. Here's a question here. We do work with Native American tribes, which are sovereign entities. Are federally recognized tribes subject to tariffs? I don't know.
I don't know.
Sorry, I don't know. That's a great question, though. I would guess no, because I don't believe they pay federal income taxes. But that's, unfortunately, I don't know. That's a really good question.
Yeah, that is a great question. I don't
But
know.
I mean, if they're not importing something from another country, if they are, I suppose, I don't think that goods that travel across, reservation borders are subject to tariffs, but I really don't know.
Well, and also it kind of gets back to the point that you said a few minutes ago, Jack, in response to another question is, if the tribe is purchasing the goods from someone not directly from, that it's gone through the supply chain a little bit, and then the price effect has already taken effect, if you will. So they could be subject to just paying higher prices due to the tariffs, even if they're not directly subject to them.
There's a comment from the individual who asked about whether the government is paying tariffs or not, and I'll just read the comment. The scenario is similar to what you mentioned. My company sells directly to a client who is a government agency, so we know that the client is already tax exempted, but in many cases we sell to a middleman who is acting on behalf of the government agency, i.e. the ultimate client. It seems like that's exactly what we describe, which is the tariffs are affecting the price, kind of from a macroeconomic standpoint, even though the ultimate client, the ultimate buyer is the government, which doesn't pay tariffs, the prices are affected nonetheless.
And I don't know if folks saw this comment from Cheryl from US Law. US Law is recording this webinar with the slides visible on the screen. And so this can be accessed on the website, the US Law website later this week, if anyone wants to see it there.
That's all the questions that I have. If anyone has anything else, now's your time. If not, feel free to reach out to myself or to Caryn after the fact. I'm sure that we'd be happy to speak on her behalf on that regard to answer questions or whatever you want to do.
Absolutely.
Okay, thank you, Caryn and Jack, and thank you to everyone for participating in today's webinar. If you wish to participate in any future roundtables or webinars, please see the link to the upcoming event schedule that I've posted in the chat. And as they mentioned, this webinar was recorded, so it will be available on the US Law website. Thank you.
Yep.
Thanks, everyone.